Yeah, good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati, signing in for company law. Yesterday, we have seen different types of companies: chartered companies, statutory companies, private companies, public companies, holding and subsidiary companies, foreign company, then one person company, associate company, so on and so forth. Now, foreign company is also one of the important topic for your examination. So, a foreign company, I already told, it is one which is incorporated or formed outside India. That means it's a company incorporated outside India and having a place of business in India. So it is a company incorporated outside India under some other statute, but it is having some place of business in India. Even though it is incorporated outside India, still it has to follow our Indian Companies Act 2013 in certain aspects. So, within 30 days from the establishment of place of business of India, the foreign company has to send a certified copy of the charter or statute or memorandum on articles of the company to the registrar of companies. Next, a list of the directors and secretary of the company giving particulars of name, residential address, nationality, business, occupation, if any. Next, third one is name and address of any person resident in India who is authorized to accept on behalf of the company the service of legal process and any notice or document required to be served on the company. The full address of the company's registered or principal office outside India and the full address of the company's principal place of business in India. Even though the foreign company is incorporated outside India, still certain provisions of the Companies Act 2013 will apply to the foreign company. Once a foreign company is registered in India, it has to give all its memorandum of association, articles of association, names of the directors, company secretary, names of any person who is resident in India and who can accept any legal process on behalf of the company's registered office or principal office, the company's principal place of business in everything India, they have to submit to our registrar of companies. Right from the beginning, we are discussing about once a company is registered with the registrar of companies, right? What happens? It assumes the character of a separate legal entity. That means company is different, members are different. Even though the members hold the entire share capital of the company, still company does not belong to the shareholders. Remember again and again, company is different, its members are different. This is the concept of separate legal entity. But sometimes courts will think that company and members are one and the same. Here, wheel means curtain, curtain, curtain. Once a company is registered with registrar of companies, an imaginary or illusory curtain will be drawn between the company and the members. Curtain means separation. So, company is different, members are different. Between the company and the members, what there will be? There is a curtain. It is known as wheel. Corporate wheel will be there. That means members are different, company is different. But Sometimes the court thinks that members and company are one and the same. That means it is going to lift the curtain and it will pass an order that company and members are one and the same. It is known as lifting of corporate veil. It is known as lifting of corporate veil. This corporate veil can be lifted under judicial interpretations, express statutory provisions. Now, let us see how this lifting of corporate veil under judicial interpretations. Let us go into the details of lifting of corporate veil under judicial interpretations. First one is determination of character of the company. Sometimes it becomes necessary for the courts to determine the character of the company, that is, to see whether it has assumed an enemy character or not, and whether the company is owned and controlled by the enemies of the country. In such cases, the court may lift the corporate veil, lift the corporate curtain, and examine the character of the persons who are in real control of the company's affairs. As a matter of fact, the lifting of corporate veil in such cases is necessary because trading with an enemy is against the public policy. For example, India is there, Pakistan is there. They are having some contractual obligations. Indian company is in foreign Pakistan, Pakistan company is in India, and they are carrying on business. Once a war has been broke out, what happens? The Pakistan company will become our enemy company, alien company, alien company. So at that time, the courts will lift the corporate veil and see whether the business carried on in India is owned by a company which is an enemy company or not. So here there is one case is there, Daimler Company Limited versus Continental Tires Rubber Company. Daimler Company Limited versus Continental Tires Rubber Company. Here what happened is a company was incorporated in England for the purpose of selling tires manufactured in Germany by a German company. Now, the bulk of the shares in the English company were held by the German company, and the remaining shares were held by the Germans residing in Germany. Moreover, all the directors of the English company were also Germans residing in Germany. Thus, in fact, the real control of the English company was in German hands. Now, what happened is during the First World War, English company brought legal action to recover the trade debts. The question arose whether English company had become an enemy company and therefore should not be allowed to proceed with the action. It was held that the company had assumed an enemy character and was debarred from maintaining the action. That is, it was not allowed to proceed with the action. The court has lifted the corporate veil to determine whether that company is an enemy company or not. Right? Second one is protection of revenue. Protection of revenue. Normally what happens is company has to pay income tax to the state. If the company is not paying tax, thereby evading, then courts will lift the corporate veil to see the real intention of the companies. Sometimes the lifting of corporate veil is necessary for the benefit of revenue, where the separate entity of the company is used for evasion of tax. In such cases, the court may lift the corporate veil and income of the company and its members may be taxed as that of 1%. To protect the revenue again, the courts will lift the imaginary corporate veil and it will tax the person as the company itself. Right? Number 3, protection of companies' own justified interest. Sometimes a company itself wants that its separate entity should be ignored and treated alike with the members. The company itself is asking the court to treat that it is somewhat in consonance with the members. In such cases, the court may lift the corporate veil. That means it will ignore the separate identity of the company in the company's own interest. Thus, the corporate veil may be lifted for company's own benefit if the court thinks it to be justified. The court will ignore the separate legal entity of the company. Remember, lifting of corporate veil is not always to the disadvantage of the company's promoters. Supreme Court in a case lifted the veil where the joint venture sponsors of the company were qualified for participating in the government tender. Their company should also be treated as a qualified tenderer. The main crux is normally once a company is registered with the registrar of companies, the company becomes a separate legal entity. However, the courts in these situations disregard the corporate entity and it assumes that company and the members are one and the same. Number fourth one is avoidance of legal obligations imposed by welfare legislations. Here, a company is there. Company has to follow labor laws, welfare legislation. Assume that one company is there. It is having more profits. If a company earns more profits, more bonus has to be paid. Now, what happened is this company, despite getting more profits, it has established some other company telling that it incurred expenses in incorporating that company instead of paying bonus to the employees. Now, sometimes it appears to the court that the company is formed just to avoid the legal obligations imposed by a welfare legislation. In such cases, what happens? The court may lift the corporate veil, ignore the separate entity of the company. Example, where in order to reduce the liability to pay bonus to its workers, the company splits up its profits by creating another company. The court may refuse to recognize the new company. Why? In fact, the legislation requiring the payment of bonus to workers is for the welfare of the workers and the company should not be allowed to escape liability imposed by such legislation. The avoidance of welfare legislation is as common as avoidance of taxation. Now, a company was earning some handsome profits. So once a company has more profits, it has liability to pay bonus is also high. In order to split up the profits into two hands and thereby to reduce its liability to pay bonus to the workers, the company created another company as its subsidiary and transferred some of its investments and securities to the new company. So the company don't want to give bonus. They have created another company. They have transferred the profits of this company to that company, thereby avoiding the legal obligations. In that situations also, what happens is company will lift the corporate wheel. Normally, remember, courts never interfere into the internal management or affairs of the company. Only in these circumstances only, courts will lift the corporate wheel and look behind who are the real persons in that company. Number fifth one is avoidance of contractual obligations. Here, sometimes what happens is a company is formed simply to avoid the obligations arising out of the contract. So, in such cases, the court may lift the corporate veil, that is, ignore the separate entity and decide the case, assuming that no company is in existence. For example, two persons are there, A and B. A and B were carrying on an auto part business in partnership. What A and B are doing? They are carrying on auto parts business in partnership. Now, A and B sold their business to C. They have sold the business to C and agreed not to start a competitive business for 2 years. They have sold their business to C. They signed an agreement that they don't what is called run the business of partnership for 2 years. Now, immediately thereafter, A and B wanted to start the similar business. So, now what they have entered into the contract, they should not start partnership business. Now, in order to avoid that contractual obligation, they formed a private limited company. They sign the contract for what? They don't carry on the business of partnership. But what they are doing now? They have formed a private limited company and they become the major shareholders and directors and they have started the similar business. Now, in this case, the court may ignore the separate entity of the company and restrain it from starting the similar business. Here it is clear that the company has been formed by A and B simply to avoid their contractual obligations. So, for determining the character of the company, for the protection of revenue, protection of company's own justified interest, for avoidance of legal obligations imposed by the welfare legislations, avoidance of contractual obligations, the court will assume that company and the members are one and the same. Remember, a company is a separate legal entity, company is different, members are different. But under the concept of corporate will, the court think that company and members are one and the same and they will lift the curtain behind the curtain between the company and the members and they will order enquiry. Sixth point is prevention of fraud or improper conduct. So, prevention of fraud or improper conduct. No, in this case also, if it appears to the court that the company is formed for some fraudulent or improper purpose, that is to deceive the creditors, to avoid legal obligations, or to defeat the provisions of law. In such cases, the company may lift the corporate veil. Lifting the corporate veil means ignoring the separate entity of the company, where the company is formed to deceive or defraud. The court will lift the corporate veil and look into the ownership of the company. So, if it appears the court that the company is formed for what? To defraud the persons to some fraudulent or improper purpose or to defeat the provisions of the law, the court may lift the corporate veil, that is, it will ignore the separate entity of the company. So, the court will lift the corporate veil and look into the ownership of the company. Number 7 is dummy companies. Dummy company means it is not in existence. Here, sometimes a company will be formed by certain persons which is not intended to be a corporate body. It is formed simply to carry on their own personal businesses. In such cases, the court may lift the corporate veil if it appears that separate entity of the company is being misused. So, right, number 8 one is prevention of fraud upon public. Sometimes what happens is a company commits a fraud upon the public, and due to which public suffer financial loss due to company's fraudulent act. In such cases, the court can lift the corporate veil so as to expose any person to liability who have committed the fraud upon the public. The relevant case law is Delhi Development Authority versus Skipper Constructions Private Limited. Here, what happens is a construction company advertised a scheme for booking of flats. Many people deposited their hard earned money with the company under the scheme. The scheme was operated with utter dishonesty and fraud, and no flat was given under the scheme. In this way, a large number of persons were deceived by the company. Here, the persons playing such fraud, though in the name of the company, can be held personally liable to the public. Alright, the basic crux is once a company is registered with the register of companies, it assumes the character of a separate legal entity. Company is different, members are different, and there is a curtain between the company and the members. But sometimes the court will disregard the concept of separate legal entity and assumes that company and members are one and the same. It is known as lifting of corporate veil. This corporate veil can be lifted under judicial interpretation, statutory provision. Under judicial interpretation, number 1, determination of character of the company. Number 2, protection of revenue. Number 3, protection of company's own justified interest. Number 4, avoidance of legal obligations imposed by welfare legislations. Number 5, avoidance of contractual obligation. Number 6, prevention of fraud or improper conduct. Number 7, dummy companies. Number 8, prevention of fraud upon public. In our next class, we are going to see under the statutory provisions how this corporate veil will be lifted. Right, students? This is Sreekanth signing off today. Have a good day.